members. Okay, and for the second approach to membership by accessions, that means that all nations that get the membership by joining into the WTO after January of 1995. That means after the born of the WTO. So those countries are called under the names of member by accessions. And and if you spend time reading through the text of the Marrakesh Agreement, then you may see that in comparing with the two types of members of the WTO, there's no differences. There's not any difference between the two kinds of membership, because whether a nation is an original one or they are members, they got the membership by accessions, they have the same right, they're gonna have the same obligations, and that's how the system designed. And then here you may have the questions arising that so if you're entering into the system after January of 1995, what things you can do, or in comparing with original membership, because they are the one who creates the system, they may have some special right dedicated to them, etc. That's it. That might be the questions you may have in your mind when you read through the textbook. And it also included in the question listed in this seminar. And so right here, I have to emphasize that between original members and member by accessions, there's no difference in rights and obligations. And that is the requirement by the organizations that all members have the same duty or pay the same attentions to the system. Now, a developing or developed country, whether they are original or they are a member by accessions, it doesn't matter. All the rights and obligations have to be applied under the same rules. That's mean under all the multilateral trade agreement listed in Annex 1, 2, and 3 of Marrakesh Agreement. Okay, and so that is all the knowledges provided in this seminar. And I would like to spend maybe here just a few minutes to make sure that you got the point with these questions. Okay, now right here. Now, because I have requested all of you to prepare those kinds of questions, and so right now I'm gonna call by chance any names of members in this class for the answers, and then I may evaluate this answer or providing more information or explanation if necessary. Right. Lê Nguyễn Thùy Trinh.
Yes.
Yeah. So, could you please share with us your point by answering question number 1, please?
Yes. I think the purpose of the review process is to strengthen members observant of WTO provisions and to contribute to the smoother functioning of the multilateral trading system. Moreover, the review mechanism serves as a valuable resource for improving the transparency of members' trade and investment regimes. Yes.
Okay. Thank you, Trinh. Is there any additional point right here? Any comments or thing that you may think that it's going to be? It's not only about just only strengthening the system. That doesn't matter for the member. But how about transparency? How can we make it transparent by those things? What they're going to do in a trade, in a kind of trade policy review? Trần Kim Phục. Phục, are you here?
Dạ. Dạ em nghe ạ.
Ok, Phụng.
Cô cũng nghe. Cô nghe em cô.
I have to stop sharing screen then I can see you. That's good.
Dạ không, cô nghe với em không cô? Em không biết nữa cô, bên này nó ồn ồn sao cô?
No, I hear you well. And so now you may like to provide further explanations regarding the trade policy review, which have just mentioned by your friend Trinh. Is there any comments or thing you would like to add to this answer? Huh? All right, she may be not here.
I guess no, because according to what I have the same opinion as her. So yeah, my answer is no. I think her opinion as well.
All right, thank you. And if you now right here, I need the class member to find out maybe sometime just the key point from the textbook which you have read, cause my guidance is just only sticking it close to what you have answered, and for a better guidance, I just extend it or introduce you to read something from this document or that document, and you have to follow that instructions. Because I will not give or provide the straightly or directly answer to all the discussion, because if you are not contribute to the answer, you never get the knowledge on your mind. Understand? And so right here, all right. Now Trinh have just mentioned that this requirement is its objective for strengthening the system and to like promoting transparency. Yeah, it's right at some point, but why they have to do so? Because when you enter into the system, you have to obey the law. And well, why the WTO not just trust its member? they cannot trust its member and leave their work for the member to do it themselves. That's because now the policies has changed. In 5 years, in 10 years, each nations have prepared their own strategies for economy development. And so the policies may change. And in some cases, these changes may affect to the multilateral trading system. And therefore, in order to make sure that that those changes will not get away from the main road of the WTO. That's mean the main road of freer trade. And so they have to make sure that that those member state policy may not get away from the aims of the organizations. And so normally the four biggest traders around the world, like the European Union, the US, Japan, and China, they have to examine their trade policy once every 3 years. And others country might spend this period as 5 years. And for the remaining countries of the organizations, they have to do the review every 7 years. So that is additional information for you to follow this point. And transparent requirement of a trade policy review also apply and only apply in the time of the WTO, but not in the times of GATT. And so that is the thing we need to mention when we talk about the development or the evolutions of the system since from the GATT time to the WTO. Okay, now we move on to question number 2. Would you please scan the WTO agreement and clarify how a decision be approved, applying consensus? Now, have you found any provisions or things that mentions how they gonna decide or they're gonna approve a decision by applying consensus rules? And I need you to point out that have you found these such kind of explanations? Now, may I invite Nguyễn Thị Thảo Vi. Okay. Now here I see Quỳnh Nga is raising her hand.
Yes, I was raising my hand because I want to ask or add some point regarding the first question.
Okay.
That in Article 10.8 of the Marrakesh Agreement, a decision to approve amendment to the multilateral trade agreement in Annex 3 shall take effect of all members upon approval by the Ministerial Conference. And the Annex 3 is the trade policy review mechanism. And I think this one point could contribute to the answer of the question why it is needed to take place the trade policy reviews under the multilateral trading system. I don't know whether that's correct or not.
I beg your pardon with the article which you have just mentioned. I cannot follow with
Article 10.8.
Okay.
The very last sentence.
For Article 10, about the amendment, right?
Yes,
of
correct.
Marrakesh Agreement.
Yes.
No, if you connect Article 10, paragraph 8, decision to approve amendment to the multilateral trade agreement in Annex 3 shall take effect for all members upon approval by the ministerial conference. That's mean this sentence?
Yes.
That's what, so you think that these sentences are connected with transparency requirement?
No, not exactly. I'm talking about, because the Annex 3 is about trade policy review mechanism.
Okay.
So I think it could somehow contribute to the answer, the reason why the trade policy reviews is needed under the multilateral trading system.
Okay. Well, thank you for this additional information, but the answer is no. Well, when we talk about Article 10, it's all about the conditions, right? That have been prepared for the amendment of the agreement under the system of the WTO. And so when you read through paragraph A, then you may see that it's all focused on the rules or the requirement that how the WTO may approve any kind or any suggestion of amendment to the MTR. That's mean the multilateral trade agreement, and so these kinds of activities are totally separated. It's not falling under the scope of trade policy review. Okay.
Oh, all right. Thank you.
Oh, welcome. And so now we come back to the second questions. Now here I may ask for volunteer rather than by calling your name. Any student here finding such kinds of clarifications of how they're gonna manage a meeting with consensus rules? Any volunteer right here? Class? All right, let me share the screen.
Can I answer the question?
Yeah, please, of course.
It's still in Article 10 of the MA agreement, the MA, and is in the first paragraph. So from the first paragraph, I conclude how to approve. I'm sorry, how WTO make decision based on the consensus. The first and foremost, that the proposal, which needs a period of 19 days for decision, will be tabled formally at the ministerial conference. And then the ministerial conference will need the consensus at the meeting of the ministerial conference to submit the proposed amendment to the member for acceptance. And if the consensus is reached, the ministerial conference will submit the proposal, the proposed amendment to the member. And if the consensus is not reached, then they will vote, decided by 2/3 majority of the members.
Right, but how can this ministerial conference now we don't care about the amendment or anything. What I'm asking is that what do you think, how the consensus is going to be run through a meeting, like through such kinds of how can we say, of conference, that at that kind of conference, whether it is ministerial or whether it's at a lower level, what I'm asking about is, okay, right now we are sitting in the ballroom of the WTO. We are ministerial conference. and now they're gonna decide or approve a specific decision. Okay, now we are considering for example the approval of a decision to amend for specific article paragraph 2 or 5 of article 3 in the GATT agreement, for example. And we are sitting here to make such kind of decision by applying consensus. And how can we do so? You may raise our hands that I support that kind of amendment, or we may put or press the button to show that no, we object. We don't support this such kinds of decision or not. How can they do so? In Article 10, it just provide the requirement of how they're gonna organize, but not provide the rules of consensus. How consensus mean and how they're gonna be applied in specific concessions or thing. Now here, if you move on to the last part of the Marrakesh Agreement, now right here, okay, are you with me right now? Just right below below Annex 4, then you may see the note added to the Marrakesh Agreement. And now here, then you may see paragraph 1 and 2. Right, now you spend just a little time reading through the text, and I may add some explanations. All right, so now right here at note number 1, they have mentioned that the body concerned shall be deemed to have decided by consensus on a matter submitted for its considerations if no member present at the meeting when the decision is taken formally object to the proposed decision. Okay, and so here this is the formal instructions of the WTO by applying consensus. Now, so if you read through the text, and then you may have the idea that if a member, okay, you may you have to point out what is the conditions for applying consensus right here. Now, if a member would like to object a decision, then the representative need to be present at the meeting, right? And so when they appear at the meeting, and when the chairman, let's say at the General Council, if the chairman of the General Council want to raise the question that should they approve a specific decision, then so when the question is raised, then those representatives of such member have to announce or to declare their objections, right? And so that's how this works. And so when applying consensus at the meeting, there's no need that all the member of the WTO have to be appear at that meeting, right? But the country that would prepare for the objections or good would like to use their veto against a decision, they have to appear at that time to show their opinion regarding the approval of such decision. Okay, and here then you see that by applying consensus is easy or not. It's maybe not easy because the WTO member have now more than 165 members, right? And so there's amongst those kinds of huge amount of members, there's maybe disagreement among them, and so it's not so easy to get the consensus. And well, normally, but the WTO, as I have mentioned earlier, that the WTO system try to keep consensus rules ongoing because it's a kind of traditional and normally inside the organizations, the member try to get on consensus. And because people usually say that the WTO itself will no longer be itself without consensus. And so how can they get on consensus on specific decisions? Well, basically, if a consensus is not achieved, and then it will continue to be run via lobby and sometime in lunch or dinner around a restaurant located in Geneva. And so they try to persuade and they try to bargain so that they can get the agreement, the support for a decision. Well, that's mean how many textbooks and document have mentioned the WTO as a kind of bargaining tools. That means sometimes a specific member, it doesn't mean that they don't support a decision, but they want another things, right? And so they use its veto right in order to achieve what they want, in order to achieve their goals. And so it's used that veto right to bargains. And that is additional things I would like to add right here so that you may understand the system. And that they are such a kind of forum, and normally when one country or groups of country want to support a kind of policy or something, they may try to against another policy of the WTO. But that's how the system works. Have you all got the point, class? Is it all clear right here?
Oh, so when the consensus is not achieved, they don't want to adjust the proposal, but they want to persuade.
That's right. That's right. Yeah, correctly. Now, well, normally that is the reason why for the approval of specific decision in the WTO may take sometimes half of a year or even sometimes years to get a decision to be approved. That is how the system works. They try to, as I say, or as I have mentioned before, that this is a bargaining tool for members to get what they want, what exactly they want. And so because the WTO is running by the member, and that is such the design of the system. And so they still keep the system in that kind of organizations, trying to get the support or at least trying to get a decision not to be objected. Okay. Now, people who sit at the meeting, people who sit there without objection, it doesn't mean that they are not support. It doesn't mean that they support such kind of decision. Okay. It just means that there's no objections and just depending on consensus, the ground of consensus is based only on the veto. and they just care about is there any objections or not, and that's all. Okay, and that leads to the difference when we move on to the third questions. When I ask what is the difference between consensus and unanimity, consensus that means đồng thuận, and unanimity that means gì? Unanimity nghĩa là
nhất trí.
Rồi, nhất trí. Now, when we compare between consensus and unanimity, now even I myself, my mind cannot be work well at the same time with both Vietnamese and English. Now here, then you can see. Now, when we talk about consensus, only one veto will destroy the chance for a decision to be approved, right? And the second thing when we talk about consensus is that now all the people are the people who sit in the meeting room at that time, which not use their veto right does not mean that they support that kind of decision, right? Is that clear right here? Now,
yes, teacher.
Okay, now when we talk about unanimity, how can we do so? How can it's going to be applied in real life? Now, a decision, in order to be approved, need to be supported by all members, right? And so right here, all the WTO member who represent, who have their representative at the meeting, they have to show that they support, right? They support that such kind of decision. And at that point, then we can point out the difference between consensus and unanimity. Okay. Any questions, comments, things? Or if not, I need to move on to other questions. Okay, right. We need to make it very, very effective right here. Firstly. All right. Now the first one, all WTO members may participate in all councils, committees of the organization. Is this right or wrong? Class?
It's wrong.
I think it's wrong.
And the reason, please?
Like for the previous explanation about the consensus, is not required for all members to be presented at the conference, but so that could be one of the explanation why not all members participate in the council's meetings or of the organization.
Any others other answers?
I did research about this question, and I figured out that all WTO members may participate in all councils, committees, etc., except appellate body, dispute settlement panels, textile monitoring body, and multilateral committee. Okay, all right. And so that's going to be the right answer for these questions. Well, normally, when we talk about participate, that means do they have the right to sit on or to sit in one council or committee under the system? Well, normally, as you have read in the Marrakesh Agreement, then normally WTO work as a united organization, and so they try to evolve all the member into each kinds of body, and for example the ministerial conference, right, and etc. And so when you jump into the system, then you may know that, hey, it is just not only these kinds of body. The system need a lot of
part, committee, and councils to support to support the system in order to work well and to meet those functions. And so there's a few or some body that may not contain all the members of the organizations, like the appellate body and even the panels, which today we're gonna mention in our today's discussions relating to dispute settlement understanding. And you may realize that some specific part or body of the WTO might not need to be composed of all the member of the organization, and so such kind of assessment is false. Okay. Now the second one. This is super easy. Is it true that all WTO regulations are included in GATT 1994? Of course not, right? So when you read through the four annexes in the Marrakesh Agreement, then you may know that the list of the multilateral agreement under the WTO system may not only contain in GATT, but also contained being contained in different agreement in services, in the TRIPS on intellectual property right. And so GATT 1994 or GATT 1997, 1994 is only one agreement among the list of full multilateral agreement attached with the Marrakesh Agreement. And so GATT is only a part of that, okay? And the first one, what does it mean by binding? And we talk about the multilateral trade agreement are on binding in the system of the WTO. And the next question is going to be, what does it mean by binding? Well, so right here, you need to search on Article 16, paragraph 4, I think. Now, please search on Article 16, paragraph 4 of Marrakesh Agreement. Now, right here, you may read the text like, each member shall ensure the conformity of its law, regulations, and administrative procedures with its obligations as provided in annex agreements. And so here, binding means that the WTO member have to, like sometimes they have to change the domestic law, or they have to adopt new law in order to follow the rules guided by the WTO throughout its agreement. And bindings mean that they cannot adopt or apply any law that go against the rules of the WTO, right? And any law, any regulation, actions have to follow on the main rules guided by the WTO, which mentions in the list of agreement under the system. That's mean binding. And number 4, we did solve this question already. And so this is all for the first seminar. And now this might not be any break. We need to move on to dispute settlement system right away. Is that all clear right here, class, regarding the first part of seminar 1? Dispute settlement. Do you have any class after this seminar?
No, we don't.
Right. So we may take a couple of time to provide a few explanation regarding what we're gonna do today. All right. Now we move on to the dispute settlement system. Okay. Now, the dispute settlement system of the WTO, as I have earlier mentioned, that it is necessary for a successful organizations, because it's need a judge there to evaluate and to decide who or which member are not follow the law, and such kind of actions have to stop right away in order to protect other member rights under the system. And so it is necessary for the WTO to build such kind of mechanism, and that is the reason why they have to prepare or design the dispute settlement understanding. Well, the WTO is so famous because it can enforce its rules throughout the dispute settlement system, although it is not a supranational organization. You all know that. And well, in the WTO, all members are equal theoretically. Now, it does not make sense to have a kind of police right here, but in the case of the WTO, also no member has the power to be the police of any other members, and the only possible mechanism of the police right here is a kind of procedural automaticity. That means trong cái tổ chức ấy, thì họ không có một cái người quan tòa hay cảnh sát nào ngồi đó để đánh giá là một cái thành viên là đang làm sai hay là đúng hết, đúng không? Nhưng mà cái cách thức tổ chức của cái hệ thống một cách tự động á, mà nãy giờ mình nói là cái procedural automaticity đó, nó chính là cái cơ sở để watch out cái hành vi của các nước. Now, they try to provide a proper mechanism for settling dispute, and these kinds of mechanisms are well supported by smooth functioning of a rules-based system. Now, all kinds of rules has been presented in the dispute settlement understanding, which we may try to figure out today. Now, when we jump into the dispute settlement system of the WTO, here are the list of websites that you need to have a look, because you're gonna have to prepare for the presentations by the next 2 weeks, and so you need to jump into these kinds of websites to get the resources. Now, normally, the legal text of the agreement has been listed in the link, and you can easily access to them via the WTO main website. And the second source is the panel and the AB reports. Đây là báo cáo của ban nội thẩm và cơ quan phúc thẩm. Now, the reports by panels of experts have been, well, let's say, it is an essential part of the GATT dispute settlement system since 1950s, and this system has been continued in the times of the WTO. And so when you check the link, then you may have the right to access to all the full text of adopted GATT report and the WTO panel appeals and even arbitrations rulings. And you can also, well, for each dispute, the website also displayed the current status, key facts, summaries of the dispute to date, and also the link entitled "All Documents" or something, where you can see many documents related to the case. And so, if you have to analyze a case in our presentations activities, then you have to get into these kinds of website to get on the report of the panels or the appellate body in order to provide sufficient answer, sufficient questions. I have to make clear my mind. Now, you have to check on this website to get the report, reading or skimming through the report to find out how you can answer the questions raised and listed in the guiding document. Okay. Now, when we talk about the end of the system, now I have to say that the WTO dispute settlement mechanism is the most widely used and effective international tribunal today, even at this year, 2021. Now, since the time it has been appeared in 1995 until 2018, there's about 600 complaints have been filed, and it's leading to approximately about 130 decisions, and most of the decisions have been complied with. And this is it's an amazing result for such kind of international court. And so, now in brief, under the WTO dispute settlement mechanism, government can challenge whether another member has reached its WTO commitments, and the decision of a panel or the appellate body are in effect automatically binding on the disputing parties, and because these decisions are adopted by the WTO, and so it's gonna apply, it's gonna binding with own disputing party, and for this kinds of mechanism, they have been prepared for what? For the first reason is that it's try to secure the compliance of all the WTO member with the cover agreement. That's mean on the binding multilateral trade agreements. They need to make sure that all the nations are follow the rules. Okay, and the second reason is that it has been prepared in order to preserve the right and obligations of the member. Now, how can they do so? If a country or if a member realize that their right has been affected by violations of another member, and then they can use the system in order to require a judgment or to make those kinds of violations stopped in order to protect their right. Okay, and thanks to this system that it helps support the predictability and security in international trade, because we have there a police, we have there a judge to to evaluate at any time we need. We have the person there to watch out the members' actions in order to follow all the rules required by the system. Now, when we talk about the objective of dispute settlement system in the WTO, there's two things you have to remember when we talk about that. The first thing, now here then you can see that the first thing is clarifying existing provisions of agreement in the system. Now, why we have to do the clarifications of existing provision in the system? Now here we have to notice that usually now the international treaty always very complicated, and it always need to be interpreted due to their complexity and wide scope and etc. And so different nations also have different idea about how to follow a rules. Now some things that it should be done like that, and something it's going to be explained like this way. And so the application of such kind of agreement may be different in different market. And so the most harmonious way to resolve these differences in interpretations of international treaty is by using a neutral process that established on, let's say, a recognized legal basis, so that such kind of body, such kind of mechanism may provide sufficient and like well-organized interpretations of such agreement, because they cannot let leave the agreement there for all members to interpret by themselves. They need a dedicated body to do so with such knowledge and like duty to do so. Okay, so the first objective of the dispute settlement system of the WTO is to provide guidance and interpretations of the binding agreement under the system. Now for the second one, yeah, a dispute settlement system is designed to solve rising conflict, of course. Now, WTO members have agreed that if they believe fellow members are violating trade rules, then they have the right. They will use the multilateral system of settling dispute instead of taking any action unilaterally. That means they will not react by themselves. They will not do punishment by themselves, but they have to use the forum for solving the conflict. That's how the system be set in order. Excuse me. Right, now we've moved on to the objective of this the dispute settlement system. Now, when we read through the text, especially at Article 3 of the dispute settlement understanding, then you may see there they declare that this system serves to preserve the right and obligations under the agreement it's covered, and to clarify those rights and obligations. That's mean how the law or how the agreement has been been written down on the agreement has been explained exactly like what on the paper, what has been written on the paper, but not to develop those kinds of rights or obligations. All the things are just to maintain, to preserve the rights and obligations which has been provided under the agreements only. And for such kinds of objective, then this system try to focus on a positive solutions to the dispute. What kinds of positive solutions has been mentioned here? It's mean that they try to solve the conflicts between the two by encourage them to find out themselves how to solve the conflict. Because if the parties themselves look back to their conflicts and cooperate to find out what's gonna make them happy to solve the rising dispute between them. If they can do so, then it's going to be easier to follow what have been agreed rather than adopting a report or the judgment. So the preferred outcome of the system is to reach a mutually agreed solutions, and so that they can have a win-win solution. It's also a kind of things. Now they try to promote mutually agreed solutions. That means all the two parties, the disputing party agrees with that solution. And in case they cannot get to that outcome, and then the system can be used later. And that is when the panel proceeding and the AB review can be used at that time. Now, and that is the objective of the system. Now, when we talk about the dispute settlement mechanism of the WTO, you have to make sure that you come back to Article 3 and to read back that they try to encourage their disputing party, their member, to solve the problem by themselves. In case they cannot solve it by themselves, then at that time, at that point, then the dispute settlement body enter into the procedures. Okay, now here we need to focus on the scope of the dispute settlement understanding. Now here I need you to prepare with you Article 1 of the dispute settlement understanding. Okay, now we have material 2.1. Annex 2, understanding on the rules and procedures governing the settlement of dispute. Now I need you to spend a couple of time to read Article 1, paragraph 1, and then I will make it a little bit clearer with these kinds of language. Okay. Now here, when you read through the text of Article 1, okay, now let's read it together. All right. Now here, for the coverage and applications of the dispute settlement understanding, the rules and procedures of this understanding shall apply to dispute brought pursuant to the consultations and dispute settlement provisions of the agreement listed in Appendix 1 to this understanding. Right, now let's keep going with this statement. The rules and procedures of this understanding shall also apply to consultation and settlement of dispute settlement between member. Okay, between member right here. Is it not? Concerning their rights and obligations under the provision of the agreement establishing the World Trade Organizations and of this understanding taken in isolation or in combination with any other cover agreement. Back here. Now, so there's a problem with my word. Okay, now on this wording, then you can find out that now this dispute settlement understanding gonna be applied to all the WTO member multilateral binding agreement. Okay. Now when you want to know which is other cover agreement, you have to jump into Appendix 1 of this agreement. Now, by the next seminar, please make sure that you have a look at this Appendix 1 to know what exactly cover agreement that can be used in this dispute settlement system in order to solve the conflict, the arising conflict. Okay. Now, so this system gonna be designed to serve its member only, and to solve the conflict arising out of this cover agreement only. And for this system, they will design a single set of rules for all dispute. Now, whatever this is a dispute arising in the fields of trade in services, arising in the fields of like sanitary and phytosanitary agreement or anti-dumping agreement, etc. Whatever kind or topics of the dispute, they use and apply the same procedures. Okay, and so the scope of the dispute settlement understanding is gonna solve the dispute arising out from its member in the fields that has been provided under the cover agreement of the system. Okay. Now here, let me get back. No, let's make it back to the slide. Now right here, when we talk about the scope of the dispute settlement system in the WTO, now we have to clarify that only measures may be challenged. Now measures right here, that's mean those are public acts and actions that has been adopted or has been done by the government, the member government. It's not action conducting by private entity like corporations, etc. Now those kinds of action cannot be cannot use these kinds of dispute settlement system. Okay, so only measures doing by a WTO member can be sued at this system. Now the second issue is only measure doing or conducting by the member of the WTO. What does that mean? Now That means that, as I have earlier mentioned, it will and only apply between and amongst WTO member. It cannot be used by other entities outside of the organizations, and that means it will not be applied in the dispute arising between the WTO member and a non-WTO member. It cannot be used. And also subnational entities or private entities, also company, NGO, etc. They cannot be the disputing party in the WTO system. So you have to make clear that who can use those kinds of mechanism in order to protect their right. Okay. Now here are some points or features that you need to have in mind. I know that it is its own technical, but you might take this chance to have a very brief idea about the system, and then you can come back to the dispute settlement understanding to read through it in order to have a clearer idea about what exactly compulsory jurisdictions, complainant-driven, quasi-judicial, what does it mean, aromaticity, etc. Okay, right. Now here, when we talk about the dispute settlement system of the WTO, then we say that it is a kind of, it has a compulsory jurisdiction. What does it mean? It means that for all disputes arising among WTO member and relating to WTO agreement, then it has to bring into this forum to solve. That's meant by compulsory jurisdiction. Now, if it's if the dispute arising out of like, let's say, GATT agreement Article 1 about MFN or Article 3 about NT, national treatment obligations, and it's happened between let's say Vietnam and China, Vietnam and the US, then it has to bring under this forum. Because the WTO announced this kind of jurisdictions, and it's required its member to bring such kind of dispute, such kind of conflict in under this forum. Okay, the next one. When you read through the text, then you may realize that it's provide very strict and detailed procedures and deadlines. They are all has been set for all players to follow when they enter into the dispute settlement system. Now they try to ensure a fast-track dispute settlement procedures, and so they provide or they require a specific schedule and deadline for them to follow. And this is like a positive point of this mechanism. Okay. Now, when we talk about the next point, quasi-judicial, what does it mean? Now, đây là cái mà mình gọi là bán tư pháp đó các bạn. Now, well, normally when a country or when an organization designed a kind of international court, but normally they have just only one level. That means, for example, a panel procedures. And at the times of GATT, there's only one chance for a case to be examined at only one level. But for the WTO, they provide one more chance for the panel report to be examined, which is can be considered as an additional level to review the case. And this kind of design is quite similar with domestic judicial system. And so that's how they call it a quasi-judicial. Nó gọi là bán tư pháp. Okay, the last point, aromaticity. This is quite complicated. but I try to make it clear right here, and then we're gonna have more time to explain it by the coming slide. Now, when you jump into the document, then you will see that a lot of procedures, which is playing an important roles in the procedures of dispute settlement. Now they apply the rules to approve a decision by applying negative consensus. Now they will not apply consensus right here, but they use negative consensus in order to move the procedures automatically. Now, if they apply negative consensus, then a decision gonna be like, of course, it's gonna be approved without no veto, without no restrictions. And I will explain it to you later about this negative consensus rule, and so you don't need to be worried about it. But right here, please keep in your mind that this kind of system tries to put the positions go on automatically, and at any stage, at any point that may lock the procedures, they're gonna apply negative consensus in order to make sure that the procedure is gonna be run automatically. Okay, I think it's better to stop right here. And then we may come back and move on by the next week. And right here, maybe I stop and provide some explanation in Vietnamese so that you can get the point. And I would love to hear your comments. That do you need any review in Vietnamese for the overview part, or we can focus on the dispute settlement understanding right now? Class?
I think that we can focus on the dispute settlement.
Okay, all right. Nào bây giờ khi mà mình nói đến cái hệ thống, cái cơ chế giải quyết tranh chấp của WTO thì các bạn sẽ nói chung là nó siêu kỹ thuật, cho nên bạn sẽ phải đọc ở trong luật. Nào ở trên lớp thì nó sẽ có những cái điểm mà mình sẽ nhấn mạnh và mình sẽ giải thích kỹ hơn cái phần nào mình nghĩ là các bạn sẽ cần support. Thì bạn sẽ thấy là như thế này nè. Đâu nhỉ? Nào cái hệ thống giải quyết tranh chấp này thì cái mục tiêu của nó là không có phải nhằm làm tăng hay là giảm quyền của các thành viên đâu. Bạn sẽ đọc ở trong cái điều 3 khoản 2 của DSU thì bạn sẽ thấy là cái mục tiêu của nó không phải là làm tăng thêm quyền hay tăng thêm nghĩa vụ gì cho thành viên hết. Nó chỉ cố gắng để đảm bảo duy trì đúng và giải thích đúng các cái nghĩa vụ ở trong cơ sở cái tổ chức này. Tức là hiệp định quy định như thế nào thì nó chỉ sẽ cố gắng giải thích như vậy thôi. Và tại sao tôi lại cần một cái cơ chế giải quyết tranh chấp như vậy là tại vì nó cần có một cái cơ quan chịu trách nhiệm làm cái việc đó chính thức, đúng không? Và có đủ năng lực để làm cái việc đó. Chứ còn nó sẽ không thể để cho mỗi thành viên tự mình giải thích cái hiệp định của WTO theo cách mà họ muốn. Tại vì tất nhiên để giải thích theo một cách, các bạn sẽ thấy là các cái điều ước quốc tế thì họ quy định thường là rất là rộng. Để chi? Nó phải được quy định với cái phạm vi rộng như vậy và với cái ngôn từ bao phủ rộng như vậy là để nó có thể được áp dụng ở trên nhiều cái lãnh thổ khác nhau, trong nhiều cái hoàn cảnh khác nhau. Và một cái lý do đơn giản thứ hai nữa là các cái hiệp định hay là các cái điều ước quốc tế thì nó chỉ đặt ra các cái rules chung thôi, các cái tiêu chuẩn chung, và các cái tiêu chuẩn thì nó phải rất là bao quát. Và vì lý do đó mà đến khi áp dụng thì mỗi nước sẽ có thể áp dụng một kiểu theo cách nào mà họ thấy có lợi cho họ nhất. Và do đó thì cái hệ thống giải quyết tranh chấp này á, cái mục tiêu của nó là để nhằm bảo đảm rằng các nước thành viên phải tuân thủ các cái hiệp định mà họ đã thống nhất với nhau. Thứ hai nữa là để nhằm bảo vệ đúng không ạ? Bảo tồn cái quyền và cái nghĩa vụ của các cái thành viên đã được ghi nhận trong các hiệp định đó, để tránh cái việc là cái thành viên nào đấy cố gắng vi phạm nó. Và thứ ba nữa là nhờ cái việc mà nó có một cái hệ thống đảm bảo cho việc thực thi các cái hiệp định như vậy, cho nên nó sẽ làm tăng cái tính dự đoán trước và tính an toàn ở trong cái hệ thống thương mại đa phương. Rồi, khi mà mình nói về cái mục tiêu của cái hệ thống này, như là nhiều lần mình nhắc với các bạn, là nó sẽ chỉ cố gắng làm rõ những cái quy định đã có sẵn thôi. Nó không có quyền được giải thích, tăng thêm một cái nghĩa vụ nào đó, hay là tăng thêm một cái quyền nào đó đối với các thành viên. Những cái gì ở trên cái ngôn từ của hiệp định quy định ra làm sao thì nó chỉ có quyền và có nghĩa vụ là giải thích đúng như những gì được ghi nhận ở trong luật. Và cái nghĩa vụ thứ hai hay là cái mục tiêu thứ hai của cái hệ thống giải quyết tranh chấp này là nó để nhằm giải quyết tranh chấp, đúng chưa? Như vậy là khi mình nhắc đến một hệ thống giải quyết tranh chấp của WTO thì nó có hai cái chức năng, và nó cũng là hai cái mục tiêu của hệ thống nó khi nó được design. Thứ nhất là làm rõ cái quy định của luật, giải thích thêm cái quy định của luật trong trường hợp cần thiết, khi mà người ta áp dụng thì người ta gặp những cái vấn đề phát sinh nào, được chưa? Và vấn đề thứ hai đương nhiên là giải quyết những cái mâu thuẫn nó có thể xảy ra trong cái hệ thống đó. Thì cái mục tiêu của cái hệ thống này nó cũng đặt cái nặng cái ưu tiên là nó sẽ khuyến khích các thành viên này được giải quyết các tranh chấp một cách hòa bình. Cho nên cái mà gọi là mutually agreed solution, cái giải pháp chung mà được thống nhất bởi hai bên á, nó là cái sẽ được ưu tiên, chứ không có phải là mình đưa ra tòa đây thì mình sẽ muốn nó phải có cái judgment, có cái phán quyết của tòa. Thì đấy không phải là cái mục tiêu tối ưu của cái hệ thống này, mà người ta muốn làm sao để đưa ra một cái positive solution cho hai bên. Positive solution là gì? Cái giải pháp tích cực mà họ nói đến đó, nghĩa là cái giải pháp nào mà hai bên đều đồng ý. Tại vì nếu hai bên họ đồng ý thì họ sẽ tất nhiên là tự nguyện để thực thi nó. Thứ hai nữa là nếu mà em cãi nhau với hàng xóm mà sao em thống nhất được với hàng xóm của em là ok, bây giờ tụi mình sẽ xử lý như thế này, anh bỏ bớt này, tôi bỏ bớt cái hàng rào chỗ này chẳng hạn, chỗ này tôi sẽ không trồng cái cây lấn trong sân của anh. Là nếu tụi em hai bên cãi nhau, đúng không, bây giờ tụi em có thể nói chuyện với nhau và tụi em thống nhất được cái giải pháp, thì cái đó là cách tốt nhất. Bởi vì khi mà em đã có thể nói chuyện, nghĩa là cái conflict đã được giải quyết rồi. Đấy là lý do vì sao mà cái tổ chức này họ khuyến khích cái gọi là positive solutions. Từ chừng nào mà hai bên họ không thể nào tìm ra được cái giải pháp đó, thì chừng đó người ta mới can thiệp, người ta mới đưa một cái ông quan tòa vô, kể cả cấp sơ thẩm hay phúc thẩm, để sơ thẩm chính là panel proceeding và phúc thẩm chính là AB, appellate body review đó, thì họ mới áp dụng đến cái hệ thống đó, chứ không phải là đầu tiên vô là tôi sẽ ưu tiên xử trước đã nha. Thì cái đó là cái mà tụi em phải lưu ý. Về cái phạm vi áp dụng của cái hiệp định này thì em phải nhớ cái gì? Luôn luôn nhớ quan trọng nhất ở trong cái điều 1 đó là cái hiệp định này, thứ nhất là nó được áp dụng cho ai? Nó chỉ được áp dụng giữa các thành viên thôi. Bất kể một cái đơn vị hay một cái thực thể nào khác cũng không được dùng cái cơ chế này được. Nên nếu mà hồi đó rất là lâu mình hay nghe là các cái doanh nghiệp mà xuất khẩu thủy hải sản của Việt Nam sang Hoa Kỳ bị bắt áp thuế chống bán phá giá rất là phi lý ấy, thì mình có thể kiện ra WTO vào những cái năm trước khi mà mình gia nhập tổ chức này, thì mình có thể kiện không được đâu, đúng chưa? Thế còn sau khi mình là thành viên của tổ chức này thì các em sẽ nghe nhắc đến mấy cái vụ kiện là con tôm nước ấm đông lạnh của mình bị áp thuế chống bán phá giá y chang như vậy này chẳng hạn. Mà mình thấy là cái quyết định đó vẫn là phi lý, tăng cái mức thuế nhập khẩu lên tận mấy chục %, đôi khi là 60 mấy %, thì làm sao mình bán được con tôm đó? Nhưng mà bây giờ thì mình đã có tổ chức thương mại thế giới để kiện, đúng không? Nhưng mà các cái doanh nghiệp có kiện được không? Không, các doanh nghiệp không thể nào đứng tên ở trên đơn kiện để mang ra đây được, mà chỉ có các thành viên thôi. Vậy cho nên là nếu mà mình muốn kiện thì mình làm gì? Mình đi nhờ chính phủ của mình chuẩn bị hồ sơ khởi kiện, được chưa? Cho nên cái hệ thống này khi mình nhìn vào cái điều 1 thì bạn sẽ thấy là nó chỉ được áp dụng thứ nhất là giữa các thành viên thôi, không có cái thực thể nào bên ngoài cái tổ chức này có thể dùng cái cơ chế đó, được chưa? Và nó áp dụng như thế nào nữa? Nó chỉ áp dụng cho các tranh chấp giữa các thành viên, nhưng các tranh chấp đó phải là phát sinh từ các cái hiệp định mà nó điều chỉnh kìa. Thì về nhà nhớ đọc xem các hiệp định thuộc diện điều chỉnh, cái cover agreement đấy là cái gì, nó bao gồm những hiệp định nào ở trong này. Còn các cái vấn đề phát sinh bên ngoài các hiệp định đó thì xin lỗi, cái hệ thống này nó cũng sẽ không phục vụ luôn, được chưa? Nào, chỉ tranh chấp phát sinh giữa các thành viên và liên quan đến các hiệp định và các cái nghĩa vụ hay là quyền được ghi nhận trong các hiệp định thuộc diện điều chỉnh của cái hiệp định này mà thôi. Được chưa? Và đối với các cái tranh chấp đó thì nó sẽ áp dụng duy nhất một cái thủ tục thôi. Thực ra là có một vài cái thủ tục đặc biệt mà các em sẽ thấy nó liệt kê ở trong cái khoản 2 của điều 1 này. Nhưng mà cái phần đó là phần extra rồi, mình không có đòi hỏi tụi em phải đọc tới luôn. Tụi em chỉ cần kiểm tra cho mình và nắm rõ cho mình là cái cover cái cover agreement là cái gì, các cái tranh chấp phát sinh từ hiệp định nào thì sẽ được giải quyết trong cái hiệp định này thôi. Ok, đến đây các bạn got the point rồi đúng không? Lớp ơi, bữa sau các bạn nhớ đọc trước và vẫn đọc về. Hôm nay mình đi quá chậm, đáng lý hôm nay mình phải kết thúc luôn cái bài về giải quyết tranh chấp, nhưng mà okay, bữa sau mình sẽ đi tiếp. Các bạn nhớ make sure là các bạn sẽ đọc tài liệu và những cái tài liệu mà mình đã list ra. Và nếu mà thấy khó khăn thì nhớ bạn nào có giáo trình, cái cuốn giáo trình phần 1 thì cuốn đấy cực kỳ tốt để đọc. Còn nếu không thì có cái cuốn sách của thầy Dũng và cô Quỳ cũng viết về cái hệ thống thương mại đa phương ấy, thì các bạn cũng nên đọc cái cuốn đó nếu mà lỡ vô tình các bạn có. Ok, lớp hôm nay mình dừng ở đây nhá.
Dạ cô.
Dạ cô. Goodbye.
Chào tụi em.
Dạ em chào cô.